The claim form states that she started new employment on the 21st of June 2024, 3 weeks after her resignation. It appears that her new employer was a competitor. Miss Ashwell's position is that the respondent was in fundamental breach of contract, so she was no longer bound by any of the restrictive covenants or obligations of confidentiality in her contract, and she wrote to the Tribunal on the 13th of August 2024 to complain, among other things, that the respondent had written to her new employer about these restrictions. She protested about the effect this was having on her ability to earn her living and that she was facing eviction. She does not say so, but it appears from this that she had lost her new job. Judge Fowle's framing of this section implicitly questions my competence and suitability for the role I secured, which is misleading and demonstrates apparent bias in favour of the respondent. The judgment fails to recognise that my new employment was compromised due to deliberate interference by the respondent, including repeated communications with my new employer that were designed to restrict my ability to work, effectively blackballing me. Legally, because I resigned due to constructive dismissal under Section 95 of the Employment Rights Act 1996, the restrictive covenants in my former employment contract were rendered unenforceable. By ignoring this, the Tribunal's statement misrepresents the legal position on restrictive covenants, which, under Common Law Section 27 of the Employment Rights Act 1996, cannot be enforced to the detriment of an employee who resigns due to the employer's fundamental breach. Furthermore, by stating she does not say so, but it appears from this that she had lost her new job, the judgment introduces speculative assumptions rather than relying on verified evidence, contrary to the Tribunal's duty under Rule 3 of the Employment Tribunal Rules of Procedure to deal with cases justly and fairly, including ensuring parties are not unfairly portrayed. This constitutes procedural unfairness as my documented complaints and evidence of interference by the respondent were not properly considered. In essence, this section misattributes the loss of employment to me rather than to the respondent's unlawful interference, which materially impacts the assessment of damages and my rights under employment and contract law.